Okay, well, uh, good evening to gentlemen. Uh, now, just we started this webinar. As we know, uh, as we know, this ISC Institution Innovation Council of IIMT College of Law College has organized a series of events to inculcate the youth regarding the spirit of innovation and entrepreneurship. So today we ask our uh, eminent speaker, Miss Shreya Bajpai. She is an advocate from academician. So let's give some glimpse of her profile. She has done her BLLB from Devi University, Master in Law from the famous NLU Hidayatullah National Law University, Raipur. Presently, she is working as a assistant professor in Kalinga University, Odisha. She is a well qualified NET. Her specialization in master is IPR. So uh, now I am giving my mic to our esteemed guest, Ms. Shreya Bajpai. Madam, you can carry over the session.
Ma'am, please unmute yourself. Shreya, ma'am.
Good evening to everyone present here. Myself, Shreya Bajpai. I have done my, as the introduction given by the sir, I have done my master, I have done BLB from Indore Institute of Law, DAV University, and then I have done my masters from HNLU Raipur. Presently, I am working as assistant professor in Kalinga University. Today's I'll be talking about protection of traditional knowledge under existing IPR regimes. The outline of my presentation would be, or the outline of this lecture is whether my screen is visible.
Yes, ma'am. Yes, ma'am.
Okay, the outline of today's lecture will be the traditional knowledge. We'll understand about traditional knowledge, a conceptual analysis. Then we'll move to cases of misappropriation of traditional knowledge. Cases of what's the need for bringing bringing awareness regarding traditional knowledge. So what's the need? So we'll study about the cases of misappropriation. Then we'll move forward why traditional knowledge holders should be concerned about IPR. Then we'll find existing IPR regimes, existing formal intellectual properties which extend protection to whether these formal IP intellectual properties protect extension to protection of traditional knowledge. Then we'll study about whether patent as an IPR extend its protection to traditional knowledge or not. Then we'll study about whether copyright extends its protection or not. Then we'll discuss about geographical indications. Then the suitability of geographical indications to protect traditional knowledge. Okay, so what is traditional knowledge? This is first and foremost thing is what the word term traditional knowledge means. So traditional knowledge basically is an information of indigenous people. So what is indigenous people? Indigenous people are peoples of our native people or aboriginal tribe from a native community who develop certain information which are based, and those information are based on experience and adaptation of local culture and environment, and they develop this particular knowledge or this particular information. The information is developed over time and it's a continuous development. So this knowledge is basically used to sustain the community and its culture and to maintain the genetic resources which are necessary for the continued survival of the community. Then the term traditional used is describing the knowledge that does not imply that this knowledge is old. The term traditional does not include that the knowledge is from antiquity. So but it is a tradition based because it is created in the manner that reflects the tradition of the communities. So now the nature of traditional knowledge. So what kind of nature or the characteristics is being shown by traditional knowledge. So to understand that, we'll study about the characteristics. So the characteristics being exhibited by traditional knowledge is it is of collective in nature. So what does collective in nature means? It offers the property is of entire community and not belonging to the single individual within the community. It is being transmitted, the knowledge is being transmitted through specific cultures, and it is being transmitted through the traditional knowledge has been transmitted from generation to generation, and it is a specific culture and traditional information. For the examples of traditional information, the example is if a certain community gives certain kind of traditional information orally, like some specialist breeders and healers, etc. If they're passing the information to the coming generations orally, so we can say that it is collective in nature. It does not belongs to a single individual, or it does not belong, or it does not extend its protection or to an individual, but it generates a collective right. So it is collective in nature. Now, traditional knowledge is generally described as information existing in society which has been passed on by previous generation. So it is basically a knowledge which is being passed by generation to generations, and for the sustainable development of the community. Now, if a definition, if what's the definition of traditional knowledge? So the concept of traditional knowledge is very wide, and because of its wide nature, it is very difficult to define this particular term. But then also, under Article 8J of Convention of Biological Diversity 1992, tried to define this particular knowledge, or this particular term traditional knowledge. So what does the definition was? It is a knowledge, innovations and practices of indigenous and local communities embodying traditional lifestyles relevant for the conservation and sustainable use of biological diversity. So because this definition was came into 1992, this definition of the traditional knowledge is considered as this particular knowledge is considered as very not very wide. It does not has a broad outlook or broad perspective, because it has been defined, or the definition has been given in the year 1992, when people were not aware. But when WIPO defined the definition, so WIPO gave an inclusive definition. So what inclusive? So WIPO told that all these, it mentioned certain categories which are included in protection of traditional knowledge. So WIPO is World Intellectual Property Organization, which strives for the development of intellectual property. So it gave an inclusive definition which include, or which comprises of tradition-based literary, artistic or scientific works, performances, inventions, scientific discoveries, designs, marks, names and symbols, undisclosed information and all other tradition-based innovations and creations resulting from the intellectual activity in the industrial, scientific, literary and artistic field. So when we'll study to the scope of, so what basically WIPO has done, WIPO has given a broader definition. So from the earlier which was existing. which is considered to be a narrower definition. So to study the scope of traditional knowledge, we'll look at the broader areas where we can find that this study is related, traditional knowledge is related. So it is basically a cultural knowledge. Okay, so the next is it artistic knowledge, it is medicinal knowledge, it is biodiversity or natural resource knowledges, it comprises of agricultural knowledge, it comprises of sacred know-how. So here the area in which towards which the traditional knowledge basically revolves. So if I'll simplify things to I'll try to elaborate certain examples of traditional knowledge. So this the use of plau noi in Thailand for the treatment of ulcers. So plau noi is a kind of plant which is used by Thai people, or it is a Thai or the Thai traditional healers use the plau noi plant to treat ulcers. Then if the famous is Hoodia cactus. Hoodia is a cactus like plant that grows in Africa's desert. So the San people use Hoodia cactus to stave off hunger, while out for hunting. So basically, what does Hoodia was used by the San tribe of Africa? It was used to. It was believed that, or it is believed that the Hoodia suppresses appetite. So while going for hunting, they used to eat this particular Hoodia cactus. So this is a kind of a traditional knowledge. Okay, so which is being passed on from generation to generation in Africa among the tribes who basically who go for hunting and so on. So the next is of an example of Indian example. So the use of turmeric in India. So we basically use turmeric or haldi for the wound healing, because it has a wound healing capacity. So we use turmeric for wound healing or Indian. So this is also a traditional knowledge which has been passed from generation to generation. We cannot say that this particular knowledge belongs to this century, because we are not aware from where we can trace back to the origin of this particular knowledge. So this is also a traditional knowledge. This is also a kind of traditional knowledge. The use of ayahuasca in the Amazon basin for sacred, religious, and healing purposes. So ayahuasca is a plant, or it is a drink which is been based on a bestial capi, which is used for the. It is considered that it was used by the Amazon, the people from Amazon area, or the tribes from Amazon area to use in the treatment of cancer. So this drink is being made from the plants. So this also has a sacred and religious importance among the people, among the tribe which to which it belongs, so that it is a healer. It helps in the healing of cancer. So what's the basically need for traditional knowledge, for protection of traditional knowledge, and we can protect it through how we can protect through IPR or not. So there were certain cases of misappropriation of traditional knowledge. So if we'll study about the case of ayahuasca, so in 1984 there was one scientist, Lauren Miller, who was the founder of the company of international plant medicine, filed an application for a new and distinct variety of the species Banistriopsis capi, which he discovered growing in someone's garden in Amazon rainforest, and labeled it Da wine, DA wine. Okay, so according to the patent application, Miller intended to explore plant for its medicinal use, like it was important for it has importance, or it has a value in cancer treatment. The patent was approved in 1986. So this Banistriopis capi is important, it has an important religious and historical tradition, can be associated to historical and religious tradition of Amazonian religion. So the bark of this plant basically was used for from centuries by local communities or from Amazonian or by the Amazonian people. They use that bark to make ceremonial drinks, which is known as ayahuasca, which has also a sacred religious and healing, which was used as healing the cancer. So it was also considered as a sacred drink, and it was given to the people, and it was consumed by the people as an during the ceremonies or for healing ceremonies or sacred religious practices. During that time they used to consume that particular drink. So this person, Lauren Miller, filed for the application of patent of this basically drink, which is related to the people of Amazonian tribe, which is related to an Amazonian tribe. So now what does patent do? Patent restricts or patent grants a monopoly right to a single individual. So here when a patent is being given to that Lauren Miller, that person Lauren Miller, so what it will do, what happened, it excluded the entire community. So the patent is a monopoly right, which can be which excludes the people of entire world. It grants monopoly to a single individual, and nobody can now use that particular invention or thing for the commercial exploitation. Or but this knowledge has been taken, or it is a the knowledge has been taken from the Amazonian tribe. So this apart from, the person was trying to exploit that knowledge for his economical importance, rather than it was associated to community. So community should have because it was developed by that particular community, so community should be entitled to exploit it for their economic importance or sociological importance. So but what the patent was doing, it was restricting the community from using it also, rather they developed. Second was the case of, if I'll talk about Indian context, in Indian context, so it was it is a famous case, Arokipacha plant, from which the Jeevani drug was developed and subsequently patented by Indian Research Institute of Tropical and Biological region institute. So what was this case related to? In South India, the medicinal knowledge of the Kani tribes, this Arokipacha plant was used by the Kani tribes, which led to the development of sport drugs named Jeevani, an anti-stress and anti-fatigue agent, which was subsequently patented by the Indian scientists at Tropical Botanic Garden and Research Institute. So this case is related to the knowledge or know-how of community Kani tribes of South India, and that a particular plant was used by them as an anti-stress and anti-fatigue medicine. But what did these two scientists do? They patented that particular medicine made out of that plant, which was the exploitation, which was a kind of an exploitation of traditional knowledge of that particular community of Kani tribes. Okay, so next is the case of, so these are because of these kinds of instances happening, so there's a need of a strong protection to extend protection to traditional knowledge, because here the knowledge or the know-how is being exploited for the economic benefit of individual person. and the development is by the tribes or the community. The people are not aware of the right. The people the people, the tribes is very poor, so they are not aware of the right. So by what the people scientists are doing, that they are patenting in their name and doing the exploitation of or we can say that misappropriation of that particular knowledge. If we'll study about the turmeric patent case, so turmeric patent case was also the same in 1995. US awarded patent on turmeric to University of Mississippi Medical Center for wound healing property. So after this particular patent has been granted by the US patent office to this particular Mississippi University because of wound healing property of turmeric. But we have been known from since ages that the turmeric in India is used by the by people, or is used in households of Indian people to use as an wound healing. It has a wound healing property, so it has been used in the numerous households of India. But what did the scientists from US do? They patented it. And after that, after this patent which was been granted for you by the US, then the Indian Council for Scientists and Industrial Research Organization objected that this know-how or this knowledge is associated with is an Indian traditional knowledge, and this cannot be patented because this is not because this is the exploitation of, or this is the misappropriation of traditional knowledge in India. We have been known through ages that turmeric has an wound healing capacity. So same was the case with neem patent as well. Now patent, if we look into, so now it is when we have looked into the cases of misappropriation of traditional knowledge, so it was a need, so it is a need to protect traditional knowledge. So how we'll protect traditional knowledge? So if we look into the existing formal IPR, so existing formal IPR like patent, copyright, and geographical indication, so we have to look all these areas to extend protection to traditional knowledge, because it is needed in the current scenario. So if we look into patent regime, whether the patent regime protects traditional knowledge or not, so we'll first understand what is patent. So patent provide a legal monopoly over the use, production, and sale of an invention, discovery, or innovation for a specific period of time. If I'll talk about Indian law, it is 20 years. So what does patent do? It grants monopoly right to individual or the person who has patented the invention or innovation for 20 years. Okay, so for 20 years, according to Indian law, so patent gives a monopoly right to the exclusive control over the use, development, and financial benefits received from patented innovation. So in order to, so now there are certain requirements, so prerequisites, which has to be fulfilled, then only patent will be granted. So what are the certain criteria which is to be met for an invention or innovation to be patented? It should be novel. Second is it should be non-obvious. Third is it should have industrial application. So if I'll relate patent to traditional knowledge, patent cannot extend its protection to traditional knowledge, because for patenting certain knowledge, patenting certain invention or innovation, there are certain criterias like of novelty, non-obviousness, and industrial application. So basically there are certain negative aspects of patent law which creates hindrance in protection of traditional knowledge. Like first, for patenting, first for granting patent, first, applying for a patent requires full disclosure of the invention or innovation. So, full disclosure of invention or innovation should be needed, and it should not be in public domain. But what the traditional knowledge basically is in public domain itself. So, there's inconsistency between the requirement of patent requirement and traditional knowledge. So traditional knowledge exists in a public domain, but for patenting certain invention, it should not be in public. So secondly, the invention or innovation must be novel according to patent office standards. So but if we look into the characteristics of traditional knowledge, the knowledge is not the knowledge the traditional knowledge is not a novel knowledge. It should not be a novel knowledge. It should be a tradition based knowledge. So the requirement of a patent requirement and the for protection of patent is different, and the characteristics exhibited by traditional knowledge is different. So it should not be. So there's a kind of prior art when granting patent, the patent office looks that it should not fall into the prior art. So there are various countries which considered prior art as an important standard for the protection of patent, for granting patent to invention or innovation. But what the traditional knowledge is, the traditional knowledge, it is present in the public domain. So it makes a part of prior art. So in various countries it exhibits the characteristics of prior arts. So thirdly, it is important to note that the application process for obtaining a patent can be timely and expensive. So in various countries, if you look into the patenting process, so it is yes, it is time consuming and expensive. But if we'll talk in Indian context, in India, the main problem here is the before economic expenses, the consumption of time. Like it takes long duration to give patent, and the requirement are also stringent, so it does not match with the characteristics of traditional knowledge. Then copyright on hunt for traditional knowledge. So whether copyright law will or copyright regime will protect traditional, whether protects traditional knowledge or not. For looking into this area, so copyright can be used to protect the artistic manifestations of traditional knowledge holders. So especially artists who belongs to indigenous and native communities, against unauthorized reproduction and exploitation, they can use this copyright as for the protection of traditional knowledge. So the indigenous communities or the native communities, they can use copyright as a tool for the protection or for the reproduction and exploitation of their artistic manifestation. So they can include, so it could include such as literary works, so like example tales, myths, traditions, then poems. Then if apart from literary works, pictorial works, if there's any pictorial work done by the community, the native community, so they can protect it through copyright, under copyright law or under copyright regime. If there's any pictorial, or if there's any textile work like fabrics, or there's there's a painting on fabric which is known as tapestries. So garments or carpets which has been made by the traditional people according to their traditional knowledge. So these can be in this particular way, copyright can extend its protection to traditional knowledge holders. So there was one WIPO model for the provisions of for national laws for the protection of expressions of folklore against illicit exploitation and other prejudicial actions, which was used. Basically this model came to protect the folklore of the people. So there are certain if we'll talk about the related rights of, if we'll talk about the neighboring rights of copyright, that is performers right, broadcasting right. So these are the neighboring rights of copyright. So by performers right, so performers right can extend its protection to the folklore, like to the expressions of folklore. So related rights of copyright such as performing rights could be used for the protection of performers or of singers and dancers or from the native people of or of aboriginal tribes. So this is how copyright can extend its extend its protection to traditional knowledge holders. So there are certain countries like in China, copyright protection also includes expressions of folklore. But what's the scenario in India? Indian copyright law does not include expressions of folklore, but we can bring that particular this particular expression of folklore for protecting expression of folklore in India. We can use performers right to protect it, which is an associated or a neighboring right provided under copyright law of Indian regime. If we'll talk about Indian copyright law, then there was a case of copyright on Bikram yoga. So Bikram yoga consists of 26 yoga postures and 2 breathing exercises performed at a room temperature of 105 Fahrenheit, was copyrighted by Bikram Chaudhary. He was the founder of Bikram yoga. So he founded this positions of, basically the positions of yoga and the breathing exercises, and he copyrighted those positions and basically these postures through the copyright law. But in 202 the students who taught to this these postures to students. He used this yoga in teaching. So what happened, so dispute arises when his students started gaining economic importance from that yoga, that from that for further teaching the yoga to students, and he gained economic benefit from that, which has been copyrighted by Bikram Chaudhary, and he was the founder of that particular Bikram yoga. So the student was Kim Morrison. So he filed in 2002, he filed suit against that person, that is Kim Morrison, alleging that Morrison cannot use this yoga because it has been copyrighted, or this particular form has been copyrighted by the Bikram yoga. So basically what the copyright law protects, it protects ideas, and it does not protect idea, it protects expression. So ideas, so yoga can be teach by anybody, so the idea remains in the public domain. What has been protected is expression. So the expression of that particular person, that is Bikram yoga, that he developed certain postures, or he he made certain postures, or so it was his creation, so it should be protected in copyright law or under copyright law. So he cannot, the person Bikram Chaudhary cannot have copyright in yoga. So he can, because it copyright law does not extend its protection to idea. It protects it extends its protection to expression, how you are expressing it. So basically the controversy of Bikram yoga lies here. Now in the when we'll study further, so further geographical indication is also a IPR regime, basically talks about, which basically which basically is related to which is a formal intellectual property. And if we'll see that whether geographical indication extends its protection to traditional knowledge, then under existing if under we'll see into, we have studied about patent, we have studied about copyright, and if we'll look into the other IPRs like trademark, trade secret, so they do not extend its protection, like they do not protect traditional knowledge as whole. But if there's kind of certain resemblance of geographical indication, when it's a matter of traditional knowledge. So what is geographical indication? So if what is geographical indication, so it is also termed as GI. So GI identifies a good as originating in a territory or region or locality in that territory when a given quality, reputation, or characteristics, or the characteristics of good is attributable to its geographical origin. So geographical indication or geographical indication act basically protects or gives a tag, or gives an identification to the goods which are being associated with a region, or which we can associate with a region or a locality in a territory. So if there are certain, if we'll talk about the examples of geographical indication, so we have heard about Tirupati Laddu, then it's Rasgulla from Bengal and Rasgulla from Orissa. This has been in controversy in recent days. Other geographical indications are Muzaffarpur lychee, then it's guava from Allahabad, then it's Banarsi sari from Banaras, then it's Kanjivaram sari from Kanjivaram sari of Karnataka. Then so there are it's like Kosa silk from Chhattisgarh, and it's a kind of there's one kind of rice which has also been granted a geographical indication tag. And then if we'll go into east, then it's Darjeeling tea. This has also been given a GI tag. So basically geographical indications are if we'll talk about geographical indications, so geographical indications are identifiers, or it identifies, or it gives a tag to the goods which are been which is being attributable to its place of origin. So it has certain quality, reputation, or it contains certain characteristics which are associated with, which is attributable to its geographical origin. So geographical origin whether protects traditional knowledge or not, this is a big question. So if we look into further, so geographical indication act also does not extend its protection directly to traditional knowledge. If we look into the 2000 if we look into the 1999 act of GI, if in Indian regime, then it does not gives it extend its protection directly, but somewhere indirectly it protects traditional knowledge. So certain kinds of traditional knowledge, not also not whole, not the the scope which I told earlier, that it includes the agricultural knowledge, sacred knowledge, and so on. So it does not give extended protection to every kind of traditional knowledge, but some kind of traditional knowledge is being protected by through geographical indication. If we'll talk about India, if we'll talk in India, so GI is not direct. GI does not directly protect the subject matter of traditional knowledge. However, GI may be used to protect indirectly. So now, due to the so how what's the resemblance between traditional knowledge and geographical indication lies? So because of the territorial and cultural characteristics of geographical indications, this form of intellectual property has been identified by some observers as better suited. So because it is better suited, because it extends its protection to certain kinds of traditional knowledge than other forms of intellectual property. Like we talked about patent, and we also looked into the copyright. So, GI provides indefinite protection as compared to some other intellectual properties which provide for a definite period of time. So, when I was talking about patent law, so the patent law extends, if I will talk about in Indian context, it extends its protection for 20 years. So, it gives 20 years monopoly right to single individual. So, we cannot give traditional knowledge a definite period of protection. So it should be for it should not be restricted to certain period of time, a certain period of definite time. But if I'll talk about copyright, so under copyright law, the author, the person who is granted copyright protection, or who's been protected, whose work has been protected through copyright law. So if I'll talk in Indian context, so that particular period it is also for a definite period, and that period is 60 years, life of author plus 60 years, from the death of the author, from the day of death of the author plus 60 years. So the copyright will be protected, copyright law will protect the work of the author for the life of the author plus 60 years. So this is also a definite period of protection, but GI does not do so. GI does not have any kind of definite period of protection. Yes, it is been under GI law, it has been given that we have to after every 10 years we have to renew the GI, the organization which has been conferred with the right of GI of particular goods. So it has to like renew that particular, but it does not it does not has a give extended protection to for a definite period. So here there are suitability of geographical indications to protect traditional knowledge. So what are the suitability? So geographical indications are not intended to reward innovation, as we have looked into patent law, or if as we have also looked into the copyright. So what does patent law do? What does patent law protect is it rewards for the innovation, or it rewards for the invention. But geographical indication, if you will study about the act or geographical indication act, or about the concept, then you'll find that it is not intended to reward innovation. Further, it is based on the concept of collective right. So when I was talking about the nature of traditional knowledge, so traditional knowledge is also somewhere related, or is related to collective rights. So here the resemblance exists between geographical indication and traditional knowledge, because geographical indication also extends its gives protection to the community. So traditional knowledge also is a community right. So here the resemblance exists. Further, geographical indication can create economic rewards for producers who use traditional methods in the region where the product has been traditionally produced. So through traditional knowledge or through geographical indication, we can, or the producers who are making certain goods through that particular knowledge can be protected, that product can be protected, and that particular community will be benefited by the geographical indication tags. So here geographical indication can be used as a tool to protect traditional knowledge, suitable tool to protect traditional knowledge. So there are, they are, geographical indications are designed to reward goodwill and reputation created over many years or even centuries. So for what the geographical indication is granted to particular producers, because it there's with that particular goods, goodwill is associated, reputation is associated from many years, or even we can say that from centuries, and they do not confer monopoly right over the use of certain informations. But we cannot say that geographical indications also protect traditional knowledge as whole, that it can be used as a tool for protecting traditional knowledge. It can only used as a tool for protecting traditional knowledge, but there's sui generis protection is needed, because it only tries to protect certain kinds of traditional knowledge which are being through that particular knowledge. When there's any goods is being made, so that goods is being protected, but that knowledge is not protected. So by geographical indication, the knowledge which is associated with that particular aboriginal tribe or indigenous tribe is not protected. If using that knowledge any goods is being produced, then only it can be protectable under geographical indications. So there are certain limitations also associated with the protection of traditional knowledge. So geographical indications can be used to protect only certain kinds of traditional knowledge. First, geographical indication identifies a goods. So secondly, geographical indication protection is of assistance only where the knowledge is associated with a defined geographical area. So for that also, for for a GI tag, the goods which is being granted GI tag, it should be associated with a defined geographical area. But if we'll look into the certain knowledge of Indian knowledge, like if we'll look into Triphala, which is the Ayurvedic medicine. So the knowledge is being scattered in various parts of India. So this also cannot. This is also a limitation of geographical indication to extend its protection to traditional knowledge. Thirdly, the goods must enjoy a commercial reputation. So commercial reputation is also needed in order to protect geographical indication. So here also limitation being created. But there are certain GIs, if we look into the, especially from India, which has given extended its protection to traditional knowledge. So if I'll talk about the case of Aranamulla Kanadi. So Aranamulla is a place. So Aranamulla Kanadi is a good, it is a kind of mirror. It has been granted GI tag, and it has been made by using the traditional knowledge by traditional families. So here the relation, so GI can be used, it can be used as an effective tool to protect traditional knowledge, but it is not appropriate to extend its protection to all kind of traditional knowledges. So Aranamulla is a rural place in Kerala. This is a rural area and the place is known for the peculiar type of metal, that is combination of tin and copper. So the mirror made out of this tin and copper is called Aranamulla Kannadi. So this particular mirror is of high quality which is made of metal. So this makes a difference from ordinary mirror, and it is in great demand in international as well as if you look into the national area. So this basically this mirror is in a great demand. So only few traditional families are engaged in the production of this metal mirror. So there's a belief that the basically this mirror has its ancestral origin in its from Tamil Nadu, so from the state of Tamil Nadu, and then the knowledge was brought to Kerala after approx we can trace back it to 500 years ago. So by Maharaja of Travancore for the construction of temple. So he brought this particular knowledge from the state of Tamil Nadu. Its origin is its origin can be said that it was originated in Tamil Nadu, then it was brought by the king of Travancore in Kerala. So using that metal combination of tin and copper, and it has been there's a kind of mirror which has been formed by the traditional families. Only few traditional family make it, and there's also a belief that secret behind the production of Arunamula Kannadi is given to the female member, one of the female member of the family by Lord Krishna. This is a myth. This is a belief that it was being given, but in reality also only a family consisting of 52 members is having the knowledge to make this particular kind of mirror. And this particular kind of mirror is also being given GI tag, protected through geographical indication. So the belief of the people from Aranamulla is they say that if they will tell the knowledge to other people also, that how they make they'll not be able to make it, because it's a kind of knowledge and it is a kind of practice. They have acquired this from ages, through ages. Next is the Pashmina
Excuse
invention.
me, madam. Hello. Hello.
Yes,
Excuse me, madam.
yes, yes,
Madam,
yes, sir.
time limitation is 6, madam, 6 p.m. So,
Yes,
can
sir. Sir,
you?
I'm just concluding. I'm on my concluding part.
Okay, okay.
Yeah, so the pashmina. So pashmina is also, we all know that pashmina is a kind of shawl which is we can associate from Kashmir. It is a kind of, so the particular pashmina has been obtained by the Himalayan coast from there, and the shawl is being made. So the manufacturing process of the shawl is it is a kind of traditional knowledge. So it is been enumerated in a kind of poem. So the head of the family it says the poem, and behind that head of the family sits the people, and he recites a poem, and the procedure of making that pashmina shawl is in that particular poem. So this is also a traditional knowledge, or we can say as expression, traditional expression. And then by reciting it in a poem, reciting it through a poem, that head of the family who recites, the other members of the family, they make that shawl. So those members of the family who make pashmina are also being given geographical indication tag. So this is how, if we'll talk about in Indian context, the geographical, these are the examples through how geographical indications is protecting the traditional knowledge, but not all. Then if coming into the concluding area, there are number of tools which exist its protection to traditional knowledge. First and foremost is the list of in the list is patents, but it does not protect traditional knowledge. It does not extend in a very broad way in India, then in national level, India's Biological Diversity Act exists. It is of the act is of 2002. It was enacted to provide the conservation of biological diversity. So hereby access and benefit sharing, through access and benefit sharing, the people of indigenous people or the tribes are being the knowledge of the tribe is being protected, but it is also not very apt tool, we can say that, which extends its protection to traditional knowledge. Now the question arises, which tool can be considered as an effective tool to protect in the protection of traditional knowledge? So to answer this question, GI, we can associate GI because geographical indications are location specific and are associated or emanate from a culture and tradition of the community or region. So it can be considered as an effective tool due to this particular characteristics. Then GI affords collective rights and thus is more suited for the protection and promotion of traditional knowledge than most of the existing IPR regimes. Though GI is an effective tool for protection of traditional knowledge, yet cannot completely solve all the issues relating to traditional knowledge. So the basically here's the need of sui generis legislation, like the sui generis legislations for the protection of traditional knowledge. Other traditional knowledge, digital library exists, other things exist, but then also they are not extending its protection completely to traditional knowledge. So thank you everyone. Thank you for listening me so patiently. Thank you.
Okay, madam, you have wonderful after session on this particular topic, protection of traditional law under the IPR regime. If anybody have inquiry, you can ask to our esteemed guest.
Any questions?
Okay, well, now I propose the vote of thanks. We are just concluding this session on the behalf of IIMT College of Law. Thank you very much, madam, for such a knowledgeable and wonderful session. And thanking you all the participants for being such a patient listener. All of us has learned a lot of today. It has been very interesting session today. Thanks to everyone and good evening.
Thank you, sir.
Thank you.
Thank you, ma'am.